Supreme Court of Florida is now in session. Please be seated.
We now take up the final case on today's docket, the State of Florida versus Pacchiana.
May it please the Court, Melanie Del Cerber on behalf of the state. And I would like to reserve 5 minutes for rebuttal. This case is about a prosecutor's gut feeling based upon 20 years' experience that a Jehovah's Witness can't sit in judgment. Counsel for the defense did not contest the reason. They contested whether or not the prospective juror was actually a Jehovah's Witness. In this case, the judge did the right thing. The juror was brought back into the courtroom. They inquired and determined that the juror was, in fact, a Jehovah's Witness and confirmed the prosecutor's gut feeling, which was not contested. This isn't the type of invidious or flagrant commonplace discrimination that was anticipated by Batson. This case boils down to who we are versus what we believe when we're in the courtroom.
Let's assume for the moment that religion is a protected basis under the Batson line of cases. So assume that for me for a moment. What would be, under our case law, under Melbourne, the proper way to preserve that objection?
To ask for a religious neutral reason.
Okay. Did that happen here?
No.
There's actually a few things that need to happen. They need to object, say, I object to the strike. They need to say, as I understand it, and please correct me if I'm wrong, that identify what protected class the juror is from. In this case, it would be religion, a Jehovah's Witness, and then ask for a race or a religious neutral reason, correct?
Yes.
Were any of those things missing? Which parts of those things were missing here?
Well, that brings me to that. In this case, it's clear it wasn't preserved because at the time, this happened during a second week of jury selection. At the end, the prosecutor asked to strike the juror. The defense counsel specifically asked for a race-neutral reason. We have the prosecutor's explanation in this case.
So they made a race objection.
They made a race objection.
Which was preserved.
Which was preserved.
Right.
Let me ask you. When the prosecutor exercises peremptory challenge, transcript says defense counsel, his first response was, "Can we have a race-neutral reason?" He used the word race-neutral reason.
Yes.
But here's what the prosecutor said. She's a Jehovah's Witness. I've never had one say, and I highlighted it, they always said they can't sit in judgment. She never brought it up. So is what you're saying that had the prosecutor said, can we have a religion-neutral reason, that would have preserved it?
The defense counsel.
Defense counsel, yes.
Well, no, because that goes to whether or not religion is covered under Batson.
Well, again, assuming it is, had the for purposes of preservation is concerned, had he said or she, can we have a religion-neutral reason?
Yes, this court said that in Smith, that the defendant, the opponent to the strike must say that the person is a member of a protected class and ask for a reason, which in this case would have been religious neutral, if it had been preserved that way. And I recognize the transcript.
What is the reason that we ask that be done? For what purpose?
To put the court on notice.
Okay, how about the prosecutor saying, well, she's a Jehovah's Witness? Doesn't that put the judge on notice that the reason I'm excusing her is because of her religion?
No, what puts the judge on notice is the reason he's concerned about that is because in 20 years of experience, which wasn't contested by any counsel in the courtroom, the prosecutor said, I've never had a Jehovah's Witness who's been a prospective juror say they can sit in judgment. That was the reason. It's based on a belief, which is something that a peremptory has always been proper for, to contest a juror based on a person's belief, which is intuitive, and that is exactly what a peremptory challenge is meant for.
Wasn't the religion, the Jehovah's Witness, was offered as the race-neutral, genuine reason for the strike that was based on race? In other words, I'm not striking based on race. I am striking because I believe a juror of this religion cannot serve on the jury.
Yes, Your Honor.
Okay, so that's the reason it's given, and that's what ends up being argued about the genuineness of that given reason, correct?
Well, that's how it comes about, because what happens in this case
is... Sorry to stop you there. This would have played very differently if the strike was, Your Honor, I object to that strike because of a religious-based reason. The juror is a member of a protected class, again, assuming it is a protected class, Jehovah's Witness. This would have played out very differently, would it not have?
If the objection had been made properly, I think it would have. Then the judge would have been on notice what he was considering at the time the juror was challenged.
Have we excused in any way that you know of the failure to go through well, let me back up a second. In Melbourne, were we any less clear than saying a party objecting to the other side's use of a peremptory challenge on racial grounds must A, make a timely objection on that basis, B, show that the venire person is a member of a distinct racial group, and C, request that the court ask the striking party for the strike. And these initial steps are met, step one. That's what sets the whole thing up that comes and follows,
Step
right?
one, yes.
If that's not followed, do we even have a record by which we could make a determination?
No.
All right, so
If it's not properly initiated, which is the argument that was raised with respect to preservation, is if it's not initiated properly, the trial court cannot make the ruling because there won't be an analysis.
on religious grounds.
On religious grounds.
Okay, I want to back up even a little further than this. Show me where in the Fourth DCA's decision it construes a provision of the United States or Florida Constitution. And what does it mean to construe?
Frankly, it's in part 2 of Judge Levine's decision. Kind of at the end, it's kind of a sum up that it violates the state and federal constitutions with respect to equal protection.
There's no doubt that he finds a violation based on what happened here, but where is there a construing, and what does it mean to construe a provision of the United States and Florida Constitution?
Well, I would say in this case, it's the extension of Batson, because this court, for as long as Batson and Neal have been the law, has never included religion as a basis. This
Except
court has always said race,
I understand
gender,
that, but
ethnicity.
Batson's a case. Certainly extending a case law, there's no doubt that he did that. But how does that construe a provision of the Florida and United States Constitution?
It construes the Equal Protection Clause as it relates to a criminal jury trial and balancing equal protection of a person's right to serve on a jury against the defendant's right to a fair trial, the state's right to pick the jury.
What about the constitutional prohibition on religious tests? Doesn't the court address that also?
The court did make an aside, I think it was almost an aside at the end of the opinion that this results in an improper religious test.
Well, but it's
Well,
not
that's not an aside, that's a conclusion.
Right, he talks about Article 6, Clause 3 of the United States Constitution. I mean, that's a specific reference to the United States Constitution, correct?
Yes.
Is a reference enough, though? What does construe mean?
Well, that's where I was going. It seems as though that was almost, and frankly, an afterthought after writing the entire opinion to come through and say, well, you know what, in this case, it was all about religion. And that's really not what this record says. This record is about the prosecutor's experience with Jehovah's Witnesses as prospective jurors, that they cannot sit in judgment. It's based on a personal belief. So it's not a religious test that every Jehovah Witness may not sit on the jury. Here, the judge, what was contested was whether or not the juror was in fact a Jehovah's Witness. So the judge did the right thing and had to find out, well, you put this on your...
I'm sorry to interrupt. I'm sorry.
Go ahead.
Going back to the opinion, I just want to stay on this here. The last, again, on the second full paragraph of the opinion, the last full sentence, third, striking a potential juror based entirely on her particular religious affiliation without any evidence that her religion will prevent her from being a fair and impartial juror is an impermissible religious test in violation of the United States and Florida constitutions. And I don't know what else anyone has to say.
Well, defense counsel didn't contest that the religious beliefs in this case that a juror can't sit in judgment. So therefore, there was no record for the trial judge to go on and make a genuineness argument with respect to that. What happened here was, now, and I think it's very important to see that even after the juror was brought in, 2 to 3 times, counsel reiterated at the time the juror was struck, we need this court to put the race-neutral reason. The trial court was not on notice that this was an issue at the time the juror was struck during the second week of jury selection.
Was there a genuine...
I'm a formalist when it comes to things. I like things nice and tight and, ask the right question, ask the right thing. But it doesn't always happen that way. And the whole issue here is, was the judge on notice? And the prosecutor basically told them, she's a Jehovah's Witness. We know they don't, Jehovah's Witnesses, according to the prosecutor, they've always said they can't sit in judgment. I mean, what else does a judge need to know to make a proper ruling? I understand that the right buzzwords weren't used, but what else, if putting the judge on notice, what else does the judge need to know?
Well, the problem becomes that in this case, defense admits that Batson has not been extended to cover religion, particularly in this case, Jehovah's Witnesses, and that's what the judge was not on notice of at the time of the strike. It wasn't until 5 days later, which I think shows that defense counsel knew this wasn't preserved at the time of the challenge. The defense counsel files a motion alleging Batson for the first time. The state says on the record, this is untimely, and you know, the judge goes through and says, this has not been extended to religion. I'm denying it became a motion to strike the panel, which typically motions like that are filed in pattern cases where defense counsel has filed a motion alleging a pattern of discrimination. Here, for the first time, the trial judge was put on notice 5 days after the juror was struck, and then a hearing was held 7 days after. That is not how Melbourne is initiated under this court's case law.
Well, I mean, our law with respect to impermissible peremptory strikes, unconstitutional peremptory strikes, has always required a contemporaneous objection. Isn't that correct?
Yes, it is. Has
And
always
then you
required.
also have to renew that objection at the end, correct?
Yes, pursuant to
But
joiner.
you can't revive or renew something that never was contemporaneous, an objection that was never contemporaneously made, correct?
Yes, Your Honor. That's really the preservation point here, is to make a race-neutral objection during the first hearing and reiterate it 3 times after the jurors brought in to confirm what was written on it and granted on a questionnaire.
And there's no doubt that the fact that she was a Jehovah's Witness in his experience was that they could not sit in judgment, that they had beliefs that would make it difficult. That is, everybody agrees that's a race-neutral reason, correct?
Yes, and so did the Fourth DCA. Judge Gerber and Judge May agreed it was a race-neutral reason.
What I mean, isn't it odd? Was there a genuineness finding made when the objection was made?
At the time of...
Was the word genuineness used, or genuine?
Well, here, the judge, I have the transcript right in front of me. Over the defense objection, I find the record supports a race-neutral reason because of the concern of her responses. There was another comment, the judge granted the strike. You need to put the race and reason on the record, race-neutral. And the judge goes through an analysis of, she's a Jehovah's Witness. I think there's some discussion about her and the issue of sentencing and what she talked about.
Can you back up there? And I want you to answer Justice Lawson's question, but again, what they say is, Judge, you need to put on the record your race-neutral reason, right?
Yes, and that's why that's so important.
So again, they go back to race, not religion.
Not religion.
Okay.
And the judge
But
goes on.
isn't that part of the problem, that after a race-neutral reason was given, everybody, the defense lawyer and the judge, kept saying, where's the race-neutral reason? I mean,
Yes, and
the
the
question, nobody went to step 2. Maybe they did in their minds, but the record doesn't reflect that they were actually going to the next step and asking whether it was genuine or not.
Well, and the trial court, I think, went on and talked about the blind record and out of deference to the moving party. It seems that there was no contest that the reason wasn't genuine. To be frank, initially...
But under Hayes, that's not required to preserve the issue, because the trial court is required to affirmatively inquire as to genuineness, which arguably he did, even though he didn't use the terminology.
Yes.
And then is affirmatively required to make the genuineness finding on the record, correct?
I believe there's some confusion in the case law about that, because
Yes,
I do
there
know
is.
that Johnson has come up to this court from the Fourth DCA on whether or not that issue is in fact preserved that way, such that we're not putting the judge in the role of being the advocate for the parties. And I think that was consistent with some dissents and concurrences issued by this court. So, and that is really what complicated this issue as it comes to the merits analysis, because it was not properly preserved. The court below was only on notice that this was a race issue. And as it relates to extending the state, the federal constitution, or Batson, this court, in its case law, has never done that. Busby, Dorsey, Smith, this court has always said race, gender, and as a result of Allen, ethnicity are protected. It has never extended it, and there is no good reason to extend it to Jehovah's Witnesses in this case, because it's something that's based on a personal belief. It's who we are versus what we believe.
Can you, go ahead.
No, go ahead, please.
You've said that a few times, and it just strikes me, I think the preservation argument is strong, but, I mean, we would never, in the context where you're talking about race or sex, you would never allow someone, if there were a peremptory challenge and then the counsel were asked for a, sex neutral or race neutral reason, we would never accept a response that said, it's not because they're, X race or X sex per se, it's because of my experience with people of that race or sex. So how, in the religion context, how would we ever be able to separate, the quote-unquote beliefs from the affiliation with the religion?
I would suggest it's actually quite clear from Smith that in that opinion, there's discussion about immutable characteristics. It's things you can see right then, right then, and they're not changing. A gender isn't going to change. Personal beliefs are ever changing, and you can go so far as Daubert in the capital sense that a person's scruples against the death penalty are a good reason for a peremptory strike.
But what's your response? I'm sure you read Justice Thomas's dissent from the denial of cert in the Davis case, where he's a skeptic about the JEB case in the first place, but he basically says, now that we've gone down this path, there's no principled basis for treating religious affiliation differently from race or sex. What's your response to that?
I would say there's no compelling reason to extend it that far, because religion, in particular Jehovah's Witnesses in this case, beliefs are ever changing. Personal beliefs have always been grounded in the peremptory challenge. It's based on intuition, but it's intuition based on personal beliefs. And in this case, we know that the gut feeling of the prosecutor about the personal beliefs, it was confirmed.
But the thing is, it's like you mentioned earlier, in the death penalty cases, prosecutors are allowed to excuse jurors who have a firm belief against the death penalty. I could never, ever recommend death. Then they're excused. Yet, that belief could change. The next case that comes up, the media could change that belief real quickly, and then that's allowed.
It could, and that's why it should be subject to the peremptory challenge, because it's an ever-changing belief, and if there's record support to show that that belief changed, that's the difference. And I think immutable characteristics that are obvious.
Well, isn't it also, it's not just the characteristics, it's the stereotypes, it's the historical stereotypes associated with those characteristics. So to assume that people of a particular race or people of a particular gender are going to take a particular view of things, that's problematic. Isn't that one of the main teachings of the case law from the U.S. Supreme Court in this area?
Yes, Your Honor, that is.
And isn't that a little different in this context, where we have people who are kind of self-identifying with a set of beliefs that are there and are known, and that's not the same type of stereotyping that's gone on in these other circumstances.
It's not, and I think what happens by extending it that way, it complicates the peremptory challenge in the sense that we're determining beliefs and things that are ever-changing, and someone may or may not subscribe to all of the beliefs, and that's why there is no good reason to extend.
Do you agree with the case law from the Third DCA that extended it to Jewish jurors?
Well, that case is different. That was based on, frankly, the Allen ethnicity analysis.
But how does Judaism and ethnicity? I mean, how is that? I know what they said. I know the language they use with ethnicity. But how do you characterize Judaism as an ethnicity, and why wouldn't you extend that same analysis to any other religion?
Well, I think because in that case, if you look at the analysis was pretty intricate in Joseph, going through it wasn't just religion, it was a community cohesiveness. It's that cognizability test, which does seem to be complicated.
So you think it could, as long as they had made the analysis? In other words, if there were studies showing that 10% of the Broward population was of Jehovah's Witnesses, that there had been historical discrimination against them?
Maybe, maybe not. I think that's the problem with this case. We don't have a record to know, and I'm not sure.
But that's different than saying that religion can never be an extension, because those are different things.
Well, that's under state case law. So that's under the cognizability analysis to determine whether or not we're going to find a protected group in a particular place in the state. That's different than extending Batson wholesale or the Equal Protection Clause wholesale. So there may be a case, but this is not it. With that, I see I've run out of time. Hopefully I'll be able to reserve my 5 seconds.
I'll give you 1 minute for rebuttal.
Thank you, Your Honor.
Morning, may it please the court. Fred Haddad on behalf of Mr. Pacchiana. Excuse me. At the moment that the prosecutor went to strike the juror and defense counsel, Mr. Williams, said, "Can we get a race-neutral reason?" She replied, "She's a Jehovah's Witness," and we through the rest of that, she never brought it up.
And that's a race-neutral reason, correct?
Jehovah's Witness?
Yeah, that's a race-neutral reason.
I don't know. I mean, it's still predicated upon a person's religious characteristics. That's why the lawyer
It's
followed
not
up.
related to race.
It's not related to race.
Huh?
It's not related to race.
No. Okay, and that's why the defense lawyer, I'm sorry, I don't know if it's the acoustics or just me being tired, but the defense lawyer right after that said, the other defense lawyer, Mr. Bogenschutz, said, counsel for, as it says in the record, that's a religious-based strike. We put the court on notice right then and there.
But here's the issue. There's not even, that's kind of the statement of the obvious. I mean, because the reference had been to Jehovah's Witness, so to say that's religion-based, in a certain sense, that's true. I mean, there's no way you could deny that.
Right.
So that's just stating what is already obvious in a way that's very different than you'd have in the typical race-based strike, where there've got to be some other things going on subsequently. So this is just a statement of that obvious fact, but there's never a suggestion that it is an improper religious-based strike. There's never, it is totally undeveloped. And then the whole context of the discussion that follows, and bear with me just a second. No, I'll give you your chance to respond. But the whole context of the discussion that follows is really focused on race. And then the judge makes the ruling that it's not a religion-based. And then nobody says, well, it makes the ruling that it's not race-based. And then nobody says, well, what about the religion objection? I mean, so how in the world would the judge really know here that anybody was asserting that there was a violation of the Constitution based on an impermissible religion-based strike? I searched through this and I don't see it. It's confusing, I will admit, but I think there has to be some clarity so the judge can really know that somebody is asserting that there's been a violation. In an area like this, where this is not the impermissibility of strikes related to religion, is a complicated area because we know that sometimes people can be properly excluded based on the religious beliefs they articulate that are inconsistent with the responsibility that they have to carry out as a juror. That's established. So in that context, it seems to me particularly, there's got to be more to put the judge on notice of what's going on. So tell me what I am missing.
After the Mr. Bogenschutz said that's a religious-based strike, the state says, you can say that for 20 years, and then he mentions me being a counsel for the co-defendant, knows any of them. They've been practicing, and they always said they can't sit. And then we go into she reads Jehovah's Witnesses stuff, what was said there, and the judge at some point, where he's pressed to make a reasoning, said, she is a Jehovah's Witness. And he goes through that and says that, I have it at the top of my head, and the one I needed, of course, I can't ever find it, but he said, make a determination after they bring her in, and he said, my reason is unchanged, and we said to the judge, one of the lawyers said, If the court has to make a ruling, granted, they said race neutral. I grant you the lawyer said race neutral, and the judge still said she's a Jehovah's Witness. He's on notice. He not only is on notice.
But the point is that's his explanation for why it's race neutral, and that there's a race neutral reason.
But
isn't it? I mean, isn't that the only reasonable way you can read what's going on here?
in part, I can't disagree with you in part, Chief Justice, but there's some other parts of this. Because again, the objection was renewed, and if you look at Joyner, that gets us through part of this, because in Joyner, the court...
But isn't it true that an objection cannot be renewed unless it was contemporaneously made? There's two steps in the process. It's got to be contemporaneously made properly, and then, before the jury is sworn, it has to be properly renewed.
I agree on that, but the purpose of that is, if all of these, is to put the court on notice what the basis is. It's just like,
on that, I think, everyone in the room would agree with that.
all right, but it's as the
question is, did that happen here?
I suggest it did. I suggest the judges singularly on notice to what the objection was. I know the lower court, all three judges found that we preserved the error, but the judge was completely on notice from the first moment of what it was, and it was about...
If the judge was on notice that there was a religious-based objection, you can't strike this. Why would the judge have said, there is a race-neutral reason she's Jehovah's Witness? That is the race-neutral reason. That he was responding when asked to put on the record what the basis for his ruling was. He was giving the race-neutral reason that was given.
I agree, just as when he said there was be malpractice to keep one on a jury. I mean, to him, it's a race-neutral reason. It's just
but that's the point. That's the only objection that he understood he was responding to, and he was ruling on, and he was giving the race-neutral reason.
I wish this court had already decided Johnson so I could figure out what to argue, where they said exactly, you know, the prosecutor was objecting to the defense lawyer excusing men and wanted a race-neutral reason, and the court said on appeal, well, we know what he meant from the context of what was being said, that he meant a gender-based objection.
I'm sorry to interrupt you, but isn't the entire, if you read this whole exchange in context, it seems to me that it all goes back to what Justice Lawson was asking about genuineness. And the irony of this whole thing to me, given your position, is that it seems like the whole premise of this was your side trying to establish that it would be okay to do a religion-based strike, but that here that this whole thing is pretextual because it hasn't been established that she really adheres to these beliefs. And so when the co-counsel says she reads Jehovah's Witness stuff, but she doesn't say that she's a practicing Jehovah's Witness, the only way to make sense of that is that that's questioning the genuineness.
I'm sorry?
Did you say that?
Me? Yes. It was I. But here's what happened is that we had jury questionnaires. And when she was brought in, nobody questioned her. The prosecutor asked his basic voir dire about, you know, if this is a pencil, can you believe this is a pencil? As just pointed out in the record, he never questioned her about anything else, and then he excused her. After that, and that's when we brought up the challenge. No one asked, and he said she didn't say she was a Jehovah's Witness, and I said, I think it was I who said, it's right there in the questionnaire.
No, but the point being that it was a pretext, that the Jehovah's Witness issue was a pretext,
yes.
That it was really race-based. And that's what, and then everything that follows is trying to figure out, does she really have these beliefs? Is she actually a practicing Jehovah's Witness? And then it culminates with the judge saying that the beliefs are there. So there's nothing in the discussion here where counsel puts the judge on notice that there is a constitutional problem with striking someone for their religious affiliation.
When we brought up the Minnesota case and all the rest of
and the first sentence of that motion is, it says in the introduction, this is a matter of, in what appears to be a case of first impression in Florida. And so that's all the more reason why it's not like something as well established as race or sex, where as soon as you say the word, everybody in the courtroom understands what the issue is. In this case, just saying it's a religious-based strike, that doesn't tell the court anything.
And you didn't raise it prior to the jury being impaneled?
We did.
You raised that particular issue of religious,
absolutely.
that she was
raised,
religious discrimination?
For mistrial
In fact, counsel, right after voir dire were before the jury was sworn, you filed a written motion for mistrial.
Yes, and we filed
And there was,
prohibition.
and to select a new jury. And at the hearing on that motion, just to clarify what the judge was on notice of, here's what the judge said: Jehovah's Witnesses are peculiar, and I'm quoting, and many of them, in my experience, has said they cannot judge, that God judges. And based on that, I find that no genuine non-race-based reason. And he goes on to say, so the fact that she says, the juror says, that she's a Jehovah's Witness, notwithstanding the fact that she says she can still be fair and impartial, he says, you know what? I don't feel comfortable with the fact that she has that religion. Then the last paragraph in that quote, a Jehovah's Witness, that as a religion, it would almost be malpractice for a prosecutor to let someone on the jury like that. The judge said that.
Yes, absolutely.
So I think the judge is on notice. I don't know what else you need to prove.
Let me ask something very different, and that is, wouldn't you agree that there is no indication whatsoever on this record that an impartial jury was seated in this case? I mean, your client got a fair and impartial jury.
I lost, I don't know.
Not as impartial as you wanted.
Yeah, absolutely. They were out 4 or 5 days, but that didn't help. But what can I say? I mean, we certainly didn't move to strike any more jurors. We didn't move for a new trial. We moved to interview jurors. That was denied because of some comments that were made, and I don't know if that's in this record before this court, because of some mafia comments.
In this context where you're putting all of these resources potentially into a retrial, isn't it, even though you have no harmful error during the trial and you've seated a fair and impartial jury, there's no indication otherwise, don't you think it's important to have rules that say if you're going to make an objection that's going to cause the people of this state to go through the whole process again, even though there's no indication that the process was unfair to the defendant or to the state, that you ought to have some real good preservation requirements for an objection under those circumstances that would allow the trial judge to understand what the basis for the objection is and to rule on it and consider it at the time that he's dealing with that potential juror?
Let me answer that 2 ways. One, I think that when a juror is improperly excluded, certainly with race, it mandates a new trial every time. I've never seen it not mandate a new trial. It would be the same here with a religion-based objection, I would assert. A, and B, the judge was on notice. This was all, I mean, I understand the wording was not as it should have been, but there is certainly no question Judge Levinson, from the first instance, knew that we were complaining about the exclusion of the person as a Jehovah's Witness who stated that she could be fair, that she could listen, as long as it wasn't passing sentence or a death penalty case, she could be fair.
Well, but again, I think if you look at all this in context, I think the judge can be understood as, his comments can be understood as emphasizing the point that this strike, based on her association with the Jehovah's Witness, is not a pretextual ground that's been given for her exclusion on the basis of race, which was the objection that was made. And then can't that reasonably be understood from this whole context, from the beginning to end?
I mean, we can both understand different ways about what was said, but yeah, I mean, one can take it one way, one can take it another, but the bottom line is she was excluded from the same prejudice against Jehovah's Witnesses that appears in the dissenting opinion that I referenced in one of my, in my brief when Justice Douglas back in the 30s was talking about it.
But it's not a prejudice against Jehovah's Witness to say that you're not going to serve on a jury if it's your religious position that you cannot sit in judgment in court. Isn't that correct? That's not prejudice. In some ways, that's an accommodation to the religious sensitivity of a particular group.
I apologize for interrupting. I would agree with you if that's what were said below. But that's not what was said. She made it emphatic that she could sit. She had said on a civil jury, she could be fair. She could find proof beyond a reasonable doubt. If the prosecutor proved this case, she'd find them guilty. She said it without any hesitation. I mean, she was as qualified as anyone.
But once the prosecutor said to the judge, Judge, this juror is going to hold me to a heightened burden. I can meet a burden of beyond a reasonable doubt, but I can't meet this heightened guard. Are those buzzwords sufficient enough to get by?
If there were any, I hope he's not listening because I've tried 100 cases with him. If there were anything to support what Mr. Rossman said, yes. But the answer to the jury, he said, I can't meet her burden. She never said anything about her burden. She said she could follow the law. She could follow the standard, whatever it was, proof beyond a reasonable doubt.
But she had made the reference to, wasn't it clear and concise evidence?
Yeah.
Well, that's a layman's term. Clear and concise could be clear and convincing, and it would be favorable to him. That's a lesser standard than proof beyond a reasonable doubt. She said as long as the proof was there, she would find him guilty. That made her as fair as anyone can be.
Is there a problem with us trying to figure out, put ourselves in the position of the trial court in dealing with this, and second-guessing the trial judge? For example, she could have said, I can be fair in a way that was very hesitant, in a way that conveyed that I'm not so sure that I can. I'm saying the transcript could read one way, and the trial judge, I mean, you know, this is a trial attorney, and the jury, the trial judge could understand something 180 degrees from what she was saying, just given the way she was saying. So given that the trial judge who listened to her agreed with the prosecutor that, yeah, he has a reasonable basis for concern, how can we look at what she said in a cold transcript and come to a different conclusion that the prosecutor shouldn't have had a basis?
Realistically, you can look at that cold transcript and I can't think of the word I want to use, and just as if it were a flowing thing they use on television where you read a script. And if you read it, it's cohesive and it's clear that she's listening to everything that's being said and that she can follow it. There's no hesitation. There's no follow-up by the prosecutor on anything she said. There's no questioning by the prosecutor, ma'am, what did you mean by this or by that? And there's no suggestion by Judge Levinson that anything's not there other than it's in malpractice to have one. I mean, that if he said that a week later, it was his thoughts at the time. It's obvious. He didn't just formulate that opinion. And the prosecutor said for the 20 years he's been trying cases, he doesn't want Jehovah's Witnesses on his cases.
Well, no, I don't think that's what he said. I think the prosecutor indicated that during his career, Jehovah's Witnesses had said they couldn't sit in judgment and were excluded on that basis.
I don't know. I know he included me in his comment because I tried cases with him, as I said a number of times. But he said, I just had it a minute ago. Sorry. That's a religious-based strike. The state, you can say that, but for 20 years, then he says, had for co-defendant, knows. Any one of them that's been practicing, they've always said that.
Well, he starts off saying she's a Jehovah's Witness. I've never had one say, and I highlighted it, they've always said they can't sit in judgment. I mean, it's just based on his experience with hearing that from people of that religion who were in a jury pool, and they've come in and say, I can't sit in judgment.
I agree. Most of them come in and say they can't sit in judgment, but when you have a person...
So you agree with that? That's not... So you're not thinking that's just some pretextual, made-up thing?
I've tried enough cases, I think, over the years to know that Jehovah's Witnesses many times say they can't sit, but when one says she can't sit, and she has a right to sit under the Equal Protection Clause, any person has a right to sit as a juror. That's part of...
But this juror, what the state was saying is that she never brought it up. That juror never brought up the fact that her religion did not allow her to sit in judgment, and that she didn't bring up that issue.
Justice, what he was talking about is she didn't answer in the voir dire or anything. She had it in her questionnaire. We read it. The prosecutor read it, and when it came time for the strike, he said, she's a Jehovah's Witness. He didn't pull it out of thin air. He knew it from reading her questionnaire, and he didn't want to ask her about it. She wanted to sit. She said she sat before, she could sit, she could be fair. She answered every one of his hypotheticals, and the way he wanted them answered, I mean, there was no basis to strike her other than a pure strike because he didn't want a Jehovah's Witness on his jury. And I'm probably out of time.
You have 17 seconds left.
17 seconds? I would ask this
14 now.
court to affirm the wise decision of the Fourth District.
Thank you.
Thank you.
First, it doesn't matter that the juror said she could be fair and impartial because that's the standard for a cause challenge. This was about a peremptory challenge based on, as Justice Kennedy said, Chief Justice Kennedy said, the prosecutor's 20 years of experience, which everyone in the courtroom then and now agreed was something Jehovah's Witnesses have always said that they can't sit in judgment.
I'm sorry to interrupt you, but I mean, the preservation argument is a very strong argument, but do you acknowledge that if you ever were going to get to a case on the merits on this religion issue, that a case where you have a judge saying that in the context of a juror who repeatedly indicates that they will be able to do their job in this case, and then you have the judge saying a Jehovah's Witness that as a religion it would almost be malpractice. I mean, substitute Catholic, Baptist, whatever. Again, in the context of the juror saying, I can do my job here. I mean, do you acknowledge that this would be kind of an extreme case as far as if you ever were going to find that there were an impermissible, act of religious discrimination, that this would be it?
No, because that comment made by the judge wasn't made just out of thin air. It was made after reviewing the opinion of Minnesota v. Davis, where all of that language led the judge to that conclusion based on the case, because counsel had come in after the juror was struck, filed a written motion, and then 2 days later, they go in and have a hearing.
This was during the initial questioning of the juror. This wasn't after that.
The malpractice comment?
Yeah.
No, that was during the second
I'm sorry.
day. That was on the 30th. Because, I mean, this case, jury selection, and I think context is very important for purposes of that, started with jury questionnaires to pre-qualify for a 4-week trial, which we know is going to be extensive. We have 2 weeks. The first 3 days, they go through the questionnaires just for initial pre-qualification if people can actually sit. Then we get to the actual voir dire. Then we have an objection made. 5 days later, a motion is filed. And a week later, at a hearing, after the trial court has reviewed the Davis opinion, based on that opinion, the trial judge said, I'm not granting this motion because of what was said in the opinion. That's what that comment relates to when you read it in complete context. And with that said, we'd ask that the case be reversed because the issue is not preserved and the Fourth District improperly expanded Batson beyond race, gender, and ethnicity. Thank you.
All right, we thank you both for your comments. Court is now adjourned.
All rise.